Along with me is my business partner, Rebecca Chen. Today we're going to discuss about the immigration reform is dead. What is the next option that we have? We're going to discuss about the H-4 extensions by traveling to Mexico, how that may benefit you if you are looking for 180 days of EAD extension. While the extension is pending, you can be employed. What are the tricks, trades, and the hacks that are available? We're going to discuss about it. Me and Rebecca are discussing about that. Of course, we're going to discuss about January visa bulletin, how many green cards were been wasted last year, how many are expected to be wasted this year. We're going to also look into how many extra green cards we may be getting in 2023, starting that is on October 1st of 2022. We're going to also discuss about the people who have filed adjustment of status. If the child is aging out, that means the child is becoming 21, what are the options available? Now, first, is the immigration reform dead, Rebecca, or is there any chance of revival?
Yeah, so unfortunately, the most recent news is that not only are the immigration provisions that we were hoping for in the Build Back Better Act seem to be dead, but the entire bill seems to be dead based on comments by Senator Joe Manchin. So the prospects for reform through Congress, at least this year, look like it's not going to happen. So what are the options going into this next year, Rahul?
Yeah, well, we're not focused on Build Back Better America. We're focused on the immigration, at least especially our audiences, though. Definitely that if this bill is not going to be passed, they're not going to have the provisions that they put it in the House. They're not going to pass it in a separate bill as an immigration. I don't think so that's occurring right now. Most probably it's not going to occur. So let's be practical on the things. Let's assume that this Build Back Better America is dead. That means the immigration reforms that we've been discussing in the past 6 months are dead. That's for sure seems to be. The hopes that I have is that the administration relied very much on the Congress to act, and the Congress did not act. If the Congress doesn't act, Biden is going to act. He's a man of action. He has shown it in Afghanistan. He has shown it in many different ways. He has given enough chance for the Congress to act. They did not act. So now he's going to go for the executive orders, though, very many executive orders. Now, Obama did differently. He waited until he went to the 7th year or 8th year and started acting at that point of time. Biden doesn't have the patience. He didn't wait. Obama said he's going to pull it out from the Afghanistan. He didn't. Biden came in, he said he's going to pull it, and he pulled out. So I'm expecting Biden administration to take very many executive orders or pass regulations that can get better options for the employment people, though. One of the things that, Rebecca, I would suggest to the administration, and I think so administration is aware of it, but we are going to start campaigning to the administration, writing letters to the USCIS ombudsman, writing letters to the USCIS director, writing letters to the congressman, is that while the Congress is idling, doing nothing, it's time for the administration to act on the employment based. The easiest thing that I can suggest them is that, hey, why not don't count the family members? Mm-hmm. There are 140,000 green cards every year available, Rebecca, as you know. There's the INA, the provision that was passed by the Congress. It's not clear whether or not the family members should be counted. They have been historically counted, though, but they can change that provision. If they change that provision, then it will be approximately 300,000 green cards. So that will be the number one step that I would recommend. Of course, simplifying the employment-based immigration process by eliminating the interview for everybody and certain other easier steps where employment authorization should be automatic when you get the 485 receipt notice instead of filing an EAD. Steps can be taken, very many things, but at this point of time, since the bill is dead, I would suggest these things, and as we go on, we'll develop it. In January first week, we will come to you with a draft thing so that you can act on it. Do you have any other suggestions, Rebecca? What about the per country limit bill, though? It always keeps coming very close and doesn't get through.
Yeah, so we already see a question from someone in the audience asking about a bill like S386 being proposed in 2022. As far as an actual congressional bill, I would say our hopes aren't very high for something like that passing next year, especially as we go into an election year for the midterms. It is always the reason why kind of our hopes were really set on the Build Back Better Act was that if something was going to pass, it was more likely to pass this year rather than next year, where in a year where the midterm elections are occurring, it's very unlikely that something immigration related is going to pass in Congress as a standalone bill.
Rebecca, let's discuss about this 180 days extension of the EAD. Can you explain when this H4 EAD for the 180 days is extended, when it's not extended? Let's say, for example, I'll ask you a question. I want you to answer the question. My H4 is expired in November of 2021, and my EAD also expired in November of 2021. I applied for extension of H4 plus EAD. Can I start working right now?
Not right now. So in this situation, your H4 I-94 has expired, and even though you have a pending I-765 application, the main condition for you to get that auto extension of your EAD is that your H4 I-94 needs to be extended. It needs to be valid beyond the end date of your current EAD. So in that situation, you would not receive the automatic extension just if your I-539 is pending.
Let's say my H4 is expiring in November of 2021 and I applied for H4 and EAD extension. Can I go to India, get the stamping and come back and the 180 days be extended at that time?
Yes. So in that situation, assuming of course your H-1B spouse's H-1B has already been extended to November 2024, for example, if you travel and get an H-4 visa stamp renewal at a consulate and then re-enter the country with the valid H-4 visa stamp and the H-1B approval notice, the extended H-1B approval notice, CBP will give you at entry an I-94 for H-4 status valid until November 2024. Upon entry, you can resume working because at that point you have a pending I-765 and extended H-4 I-94, and you can work for 180 days.
In that case, is it 180 days from November of 2021 or December of 2021?
It's 180 days measured from your EAD end date, so from November 2021.
Rebecca, what is this thing called where I go to Mexico and I come back when I'm in H4? Can I get my I-94 extended? In the scenario, if the I-94 is expiring in November of 2021, I file the extension. Should I go to Mexico and come back with my spouse? Will my I-94 be extended?
So no, not in that situation. If your H-4 I-94 expired already in November 2021, for example, if you're going to Mexico and you do not get an H-4 visa stamp renewal, when you try to come back, you may not even be admitted into the US technically. So we have gotten some questions about this because people have heard us talk about automatic revalidation, and they ask, isn't this an automatic revalidation situation? My visa stamp is expired, but I'm going to Mexico for less than 30 days. Can't I come back and get an extended I-94? So in this situation, if you are trying to come back with an expired H-4 visa stamp and your spouse's H-1B I-797 approval notice, that technically is not an automatic revalidation situation. So automatic revalidation requires that you have in your name an I-797 approval notice with an I-94 attachment. So the H-4 spouse needs to have an I-797 approval notice with an I-94 attachment in their name that is extended. If you have that plus an expired H-4 visa stamp and are going to Mexico for less than 30 days, that is automatic revalidation. They'll let you back in even without a renewed visa stamp. But if you're just trying to come back with your spouse's H-1B approval notice, technically that is not automatic revalidation. We don't recommend that you try that.
So let me repeat what you answered it as a question format. If my H-4 is expiring in February of 2022
Right.
the stamping, and my I-94 also. And if I file for an extension of H4 and extension of the H4 EAD, and my spouse H1B is now expiring in 2024, 25, sorry. Then can I go to Mexico and come back with the automatic revalidation? And can I show my spouse's H1B approval? I would be eligible until 2025.
Yes. So, yeah.
What if the scenario where my passport visa has expired in 2019, but my I-94 for the H4 is expiring in 2022, and my spouse has extended the H1B until 2025. Now, one more time, my passport is expired, my I-94 for H4 is expiring in February 2022. My spouse H1B I-797 is expiring in 2025. Can I be eligible for automatic revalidation by going to Mexico and coming back?
Yes. So that is a situation, that is the kind of textbook automatic revalidation scenario. The difference in this case is that the H4 holder's I-94 in his or her own name, the H4 I-94 has not yet expired. Instead of it having already expired in November, if you're traveling right now, over Christmas to Mexico, your H4 I-94 is expiring in the future in February 2022. Then that is a situation where you can leave and come back with an expired H4 visa stamp in your passport and show your H4 I-94 that's valid until February 2022. And you'll definitely be admitted at least until February 2022. Something that we've been observing for the past month or so is whether in that situation, if you're coming back with the H1B spouse's H1 extended approval notice, will CBP give the H4 holder
until 2025?
Right. And so that's something we've been keeping an eye on. From our observation, the answer is yes. They are extending the H4 visa holders I-94 also until February 2025.
But there are some conditions that we want to let you know. Some of the experience that we have got it. One, this is not a foolproof thing. As Rebecca has explained, if the I-94 is expiring in February of 2022, you will definitely get admission until February of 2022. To get admitted with the I-94 until your spouse H1B expires, what we are noticing is that if you're crossing through the land and coming through the land border, they are not extending the I-94. That's what we noticed. If you are flying to Mexico and coming back, that too, they're asking, is it a meaningful entry? That means that if you're just flying to Mexico and then returning back immediately, they may or may not extend the I-94. But if you're flying to Mexico, spending 2 nights there, and you are coming back into United States, then there is a very high chance for your I-94 to be extended. Now, this is not a foolproof. This is based on the experience that we are noticing. There is nothing in the law that clearly says that the CBP can do it. It is up to their discretion to do it. As of now, they have been doing it. But as we get more exposure from people like you, I mean, we are in YouTube, we are in TVs, we are in all those things. We get a lot of feedback from you guys. That's the best thing, experience that we have. It's not just we are telling you the things, you're also feeding back the information. Based on feedback and other things, what we are noticing is that if you're flying, staying there for 2 nights and coming back, they may extend your I-94 until the expiration of your spouses. In that way, then you can continue working for 180 days within the period after your EAD expires. What if I filed my change of status from F1 to H4 and I filed my EAD? Can I go to Mexico and come back on H4?
No. So in that situation, when your I-539 has been filed as a change of status, if you depart the U.S. while it is pending, you will be considered to have abandoned that I-539 application. So the I-539 will be automatically denied. Even if you return to the U.S. before there's a decision on it, that I-539 will be denied, and then any I-765 that was filed along with it will most likely also be denied. So we don't recommend the extension by travel mechanism if you have a pending change of status application with USCIS.
Let's discuss about any other questions before we go to the next topic.
No.
Let's discuss January's visa bulletin. As I already know that the USCIS is accepting the date of filing. Unfortunately, the date of filing have not moved. Only the EB2 final action dates have moved by 2 months. So all those people who are contemplating on filing this month can also file next month also. Rebecca, can you give guidance on how many green cards were being wasted last year? I mean, we got 90,000 extra green cards because of the COVID. How many were being wasted though?
I believe when we looked at the numbers, it was something along 70,000 in that range.
Between 60,000 and 70,000 green cards were being wasted though. Now, we got this extra 140,000 green cards. Last year, we had 140,000 plus 90,000 is 230,000 green cards though. But these buggers, they only approved 160,000. They wasted the 70,000 green cards though. Now this year, Rebecca, we have 140,000 extra 150,000 extra green cards, sorry. So that will be 290,000 green cards. Last year, they only adjudicated 160,000 green cards. Any light you can throw on it?
Yeah, so we do have numbers now from this past fiscal year of how many I-485 applications USCIS adjudicated each quarter. So we do know that in quarter 4 of this past fiscal year, they approved 86,000 green card applications. So
out of the 86,000, more than 50% of them they adjudicated in the last quarter.
Yeah, within those last 3 months.
So they picked up pace in the last quarter though.
Yeah.
So if they go in the same pace though, they can use the entire 290,000.
They could, yeah.
But if they wait until the last and then they don't, that's where the problem comes in.
Exactly.
We request all the audiences, if you have not written letters to the administration to adjudicate these applications fast, please write. If people ask the things, oh, you tell us to write this, you tell us to write this, did anything work? Hey, look, here's the thing that worked. In the last quarter, they adjudicated 86,704 green cards in the employment-based category. In the first 3 quarters, though, they only adjudicated 75,000 green cards. But in the last quarter, they adjudicated 86,000 green cards. That's a good evidence. And we saw that USCIS has put in the Twitter before Charlie went, he put a big note that don't keep on sending the emails that we drafted because most of the emails were coming from our channel though. So yes, it did work and we want to keep it because even if you have not filed the 485 application though, you may want the person before you get the green card. You don't want that guy to be still waiting in the line because believe me one thing, if the priority dates don't move forward, if the green cards don't get adjudicated by the time this COVID is over, this is what's going to happen. Every year, Indians are only going to get 10,000 green cards because of the per country limit. Based on that, the inventory that we have right now, the total 290,000 green cards pending, according to the USCIS, by the end of September, and there are some extra filed later on though, out of them, more than 60-70% of them belong into Indian nationals. So assuming even if they are like 170,000 green cards, it's going to take 17 years for the priority date to move anywhere. So unless we use these 290,000 green cards, we will be in trouble. Please write these letters. That's all we can do. Write the letters to the administration. Write the letters to the congressman. The draft is provided for you. We need these things. Otherwise, they're going to waste the green card. Last year, we started the campaign late. Why we campaigned late? Because Charlie kept on telling he's expecting the USCIS to use the entire employment-based green card, 90+% of the things. That's what he said. That did not happen. I don't know whether the data that we have been provided came much later on though. So by the time we had the data, it was late. Now we know the data, what happened last year. We don't want that to be repeated. Please put the pressure on the congressman, put the pressure on administration to get this adjudicated. If they administer the cases by 86,000 every quarter, we'll be in a good shape. Absolutely. We know the first quarter, because of the Thanksgiving and the Christmas, they'll be a little bit slow, sluggish, we know that. But at least in the second quarter, if they pick up the pace though, that'll be very good. We have noticed that in cases where things went to the National Benefit Center, and I and Rebecca were discussing on one of the cases, we filed in October
2021.
October 2021. November 18th is the receipt date, and the approval date of the 485 is December 15, 2021, within under 60 days. In that, of course, we had the biometrics. We even got an RFE for the birth certificate. We responded to it. All this happened in a month of 60 days, they got it. Yeah. Now, it could be done. National Benefit Center is doing it. So if Texas Service Center comes to the same speed though, we'll be in a very better situated. Now, just don't keep us contacting guys to expedite these cases. This is, not every case goes through. There is nothing we can do to expedite these things. Please don't contact our office to expedite the EADs. Don't contact our office to expedite the advance parole. Don't contact our office for expediting the adjustment of status. If we know a method to do that thing, believe me, our line from our office to expedite, the people who are standing in the line will be from Houston to Dallas requesting us to expedite. We don't have a method, but there are some departments that are doing very good. We should thank them, and we should make sure that the other departments work in the same fashion. But anybody, if you want to contact about this H4 extension though, you could, by going to Mexico, we strongly recommend to contact our office. We would be very helpful. You don't have to contact me or Rebecca. We are a little bit more costlier. We have a H1B lawyers that are very good, very effective, and they're very good in touch with these things. You can have a consultation with them. They will guide you in getting the I-94 extension in a proper way. Anything else before we go to the next topic?
Yeah, just to emphasize that this particular, contacting representatives, USCIS, about not wasting the green cards, this does not rely on a holdout congressperson. This does not require immigration reform. For them to not waste these green cards that we have for this fiscal year, it's based on evidence. We have the evidence that they can adjudicate up to 86,000 applications within 1 quarter. They have done it. And so all we're asking is that they continue at that same pace. Evidence that they can.
Yeah.
So the ask here is not that much. We're not asking them to change any rules, regulations. This is within the current framework that we have. Just asking them to do what they did between, what was it, September and August of this year, to just continue at that pace, make the process more efficient so that these green cards that we already have do not get wasted.
On the AOS cases who have been filed, who have been aging out, guys, you need to know the CSPA rules very strictly. If any of your children are aging out, you need to check whether or not your child is protected under CSPA. Child Service Protective Act. What is this Child Service Protective Act? Is that if your I-140 is already approved, and if your final action date is current, if you have filed the 485 application, if your child is under 21, now 4 of them, I-140 must be approved, final action date must be current, must have filed the 485 application, child must be under 21. At that point of time, your child is locked. The child never ages. It's just like the heaven. Remember, nobody ages there. Everybody is 21 there. Your child will ever be 21. He will never cross 21 age. Now, there are some ways to deduct the age of the child. That is called that time period the I-140 is pending will be deducted from the age of the kid. That's called CSPA age. The normal age of the kid, which is natural age, deducted the time amount the I-140 is pending. That is called CSPA age. So if I-140 has been approved, I-140 must be approved. 485 has been filed, final action date is current, the child is under 21 under the CSPA age, the child is locked, he will never become 21. So even if your priority date will take a longer time for you to get the green card, the child is locked, he will get the green card along with you. But make sure that the child doesn't get married. That's one of the other conditions though. And if you don't understand any of these principles, you're coming very close, you may want to consult a lawyer, because that is very important. Remember, A lot of people forget that the final action date has to be current, not just the 485 file, and I-140 has to be approved. So if these two conditions and other conditions, other conditions, most people forget that the final action date has to be current, I-140 is approved. Then once the child is locked, he will never be aged, he or she never be aged under 21. They cannot be married, and they can continue doing whatever they are doing. And once the child is locked under CSP age, and if you want to not move them to F1, I mean, that is fine. I mean, I personally, if I have a kid who is aging out and the child is protected under CSPA and the age is locked for the kid though, I will let them use the EAD. I will let them use the advanced parole. I personally will do it if I were you guys. Anything on that, Rebecca?
No.
Let's go to the question and answers on this. A lot of people are asking questions about the is the bill dead? Well, bill will never be dead, but it's kind of they have given up on it. I mean, there is 51 to 50 votes there. The one vote, Senator Manchin from West Virginia said he's not going to sign up. So unless some miracle happens, then we cannot get this thing going on. Is there a possibility that immigration provisions can be passed because he doesn't, at least this guy doesn't have any objections to it? Then comes the parliamentarian who objected to the immigration provisions, and Senator Manchin and also Senator Sinema from Arizona. Both of them have backed off if the parliamentarian has backed. So practically at this point of time, doesn't look like, I mean, this is our Christmas gift to us, is that no, nothing is there for you guys. I mean, I'm sorry, but I want to give the things so that you can be prepared what practicalities are there, how long you have to wait. Maybe if you have to wait, make an alternative plans to go to Canada to get a green card from them. It may be something that you may want to look forward for. But for now, starting from January though, our focus will be more on the numbers that have been given to us should be taken, should be used. And we will start programming from January.
Arya is asking about the status of the Nebraska Service Center, if we have gotten any recent approvals. I assume that's referring to I-140s or I-485s. So the Nebraska Center is better than the Texas Service Center, but mostly because almost any service center is operating more efficiently than the Texas Service Center. I would say it's still not as fast as the National Benefit Center. I-140s, if they're in regular processing, I'd say it's still taking probably 8 to 10 months to hear anything on that, and a similar amount of time for I-485s. I-485s on their own at the National Benefit Center are still the fastest processing that we're seeing between those three service centers. And then Vipul is asking about an H-1B transfer that he is filing and asking whether an H-4 extension should be concurrently filed with his H-1B transfer. So it depends a lot on when the H-4 I-94 has expired. So if your current employer, if you have a pending extension and your spouse has a pending H-4 extension and you're about to leave this company to transfer to a different company, we would definitely recommend filing an H-4 application concurrently with your H-1B transfer in that situation. If the H-4 I-94 is still valid for a year or more, it's already approved, it's not expiring, then it may not be necessary to file the H-4 along with this H-1B transfer, as long as you keep track of the H-4 end date and either file an I-539 extension before it expires or have your spouse travel and get the visa stamp and re-enter before it expires.
Isuam 24 has a question. My friend employer filed a 485 application November 30th. He hasn't received the receipt notice. How long is it taking to get the receipt notice? Oh my goodness, this is really, some receipt notices are taking 2 months and some are taking a week's time, and some of them are going to the same address and we don't have a clue about what's going on. But is the person who filed on November 30th, is he in danger that he didn't get the receipt notice? No. There are cases that we filed in October 30th or November first week, that we haven't received the receipt notice. So not much to worry about it, even though there are some cases that we filed in the December first week that went to the same service, same address, we got the receipt notices. But we don't have a clue what's going on that. Arif has this question. His 485 is pending, and he wants to travel for health reasons and want to come back. What's going to happen for his interview though? If the interview is scheduled though, you have to come back, but if it's a health reason, we can always postpone. It's not RF, it's actually health off. Okay. Yeah, we can postpone that for a period of time. Altaf, I got your message actually in the text format. I know you are my client, and I promise you after this thing, I'm going to call you. Questions comes with regards to the H4 EAD premium processing. We have no knowledge right now at this point of time when they are going to implement it. Do you expect a spillover next year? Mink's amendment status. Mink's amendment status is right now in the air, thin air, so we're not expecting that to move anywhere. I mean, things can move. I mean, we never know though. At this point of time, as it stands though, my guess for the spillover for the next year will be 60,000 though. Now, when I look into the stats given by the USCIS, if they were to adjudicate all applications pending by the end of September 30th, they only have 292,000 applications pending though. Out of them, about 50-60,000 have some criminal history that has been pending for a long period of time, and we have more applications coming this year. If they adjudicate all the applications though, we have enough numbers to cover it. So there may be a movement next year. I don't know. If these people, the USCIS, adjudicate the entire 290,000 green cards available, there should be a movement next year. That is October 1st. But we are yet to see if the USCIS is going to adjudicate the entire 290,000 green cards.
So Vinod is asking if he is changing jobs under AC 21, does his future employer need to file the I-485J supplement or an employment verification letter to USCIS? So if the employer is willing to file something with USCIS, it may as well be the J supplement. There's no filing fee related to filing the J supplement, and it basically has the same information that they would put in an employment verification letter anyway. It's basically just the future employer describing the position, salary, work location for the position that they're offering you. It used to be that to do an AC 21 kind of interfile for a future employer, it used to just be a letter because the J supplement form didn't exist. But now that the J supplement form is there, we would recommend just having the employer file that with USCIS.
Rebecca, I have a couple of questions. I want you to answer the question though, especially when there is a EAD and advance parole pending in the adjustment of status. If they travel outside the country and they get the H1B and H4 and come back, what will happen to their EAD and advance parole?
So if they are pending with USCIS and have not been approved before they left the country, the guidance that we have is that the I-131 can still be denied due to abandonment if they leave the country while it's pending.
What about the EAD?
It can continue processing.
So you don't expect any problem for the EAD, but you may expect a problem for the I-131.
Right.
Okay, you go ahead.
Let's see. Okay, so Mayank is asking about something we discussed earlier, if they can use automatic revalidation when they have a pending change of status application. So like we said before, if the I-539 that's pending is for a change of status, that will be considered abandoned if you depart the US before it is decided. It may not be too much of an issue if they have some other way to come back, for example, getting the visa stamp and coming back with the H-1B holder's approval notice. You can still get the I-94 when you come back in. The I-539 may be denied, so you will need to refile the I-765 application, but as long as you keep that in mind, it can still be done that way.
Abhinav has this question, but I'm a little bit confused about his question. He's saying that his wife is an H4 EAD. Can his employer initiate the prompt process, file for the I-140, and after the I-140 is approved, can the employer file for a H-1B under cap exemption? Abhinav, I'm assuming that if your wife was on H-1B before, and now she moved on to the H-4, absolutely she's exempt from the H-1B number. Once she's been counted toward the H-1B number, even though she might have used the 6 years, she is exempt because now she has an I-140 approval. She's exempt and she can. But if she never had a H-1B approval, she's directly trying to move from H-4 EAD and after the I-140, no, you cannot get the H-1B because she never had a H-1B before. Venkat Sai has this question. Can I have multiple companies file for H-1B transfer but choose only one of the employer? The answer to the question is simply yes. You can have 10 companies file for the transfer, only choose one company. Rebecca, is there any way people can work for 2 companies at the same time?
Yes. So there.
Oh, really?
Yeah.
And how can they do that?
The second employer that they're not yet working for would just file an H-1B petition for concurrent employment for them. So that is an option on the I-129 form, as long as they check it as concurrent employment. Once that is filed, they're authorized to continue working for their existing employer, and then at the same time they can start working for the new employer simultaneously.
Oh. Can they work for 2 companies full time?
Yes, if they can juggle it. There's no requirement that one of the concurrent employment be part-time. It can be. If you decide to work part-time for one of the companies, just make sure it is indicated that way on the LCA and on the I-129 form. But if you intend to work full-time for both companies, that's allowed as long as that is indicated on the petition.
Rebecca, how about I have a full-time employment with one company, and the second company, can they put 20 to 40 hours in that way? Either I can work part-time or full-time with the second company?
Technically, yes. If they put a range of hours on the I-129 form, then as long as they're working within the range indicated on there, that's fine.
Ash Poe has this question that, what is the this Ravi has this question. MSc EB2 straight application October 4th, 2021. Biometrics finished. What's the timeline for the 485 approval? Well, there are some cases that filed after you got the approval, but that doesn't mean that you can just go and raise a service request. But yeah, I mean, if you have filed on October 4th of 2021, your biometrics is already finished, yeah, you have a chance of getting the approval at any time. And here is a problem, Ravi, what we have, not with you, but with some of our clients. They filed in Texas Service Center in October of 2021. And they never received the biometrics, and they call us, hey, how come this Ravi guy received the biometrics? How come I didn't receive the biometrics? Unfortunately, we can't help them. But yeah, you're lucky. I mean, you filed in October 2021, you got the biometrics finished, you're EB2 straight, you're good to go for getting the green card at any time.
Grishma is asking, can she travel to India while the H-1B amendment application for a client change is pending? So she did mention that her current H-1B approval is valid until December 2023. So it depends on whether you already have an H-1B visa stamp that is valid in your passport. If you already have a valid visa stamp, meaning you don't need to go to the consulate to get a visa renewal while you're in India, then you can travel while the amendment is pending. There's no problem. CBP really doesn't get as specific as asking about your end client location when you re-enter the country. However, if you do need to get a visa renewal, the consulates, as we know, do require an amendment for an end client change. And so if the reason the H-1B amendment was filed is, because you need to go to the consulate, then it does need to be approved before you go to the consulate to apply for that new visa.
Santosh Sindhi has this question. My daughter has 1 more year to age out. I have an I-140 approval in June 2020. Is it okay to change the status to F1? I'm assuming that you are speaking about only you have I-140 approval, you don't file the 485 application, your entire family is not in the 485 application. If you just have an I-140 approval in June of 2020, I don't see any problem in your daughter getting the change of status approved. And I just want to add to it is that we have noticed that even though for some people we have filed a 485 application, when the child is not protected by the Child Services Protective Act, that means that their priority date is not current, or there are different circumstances they're not protected by it. So when they're aging out, even though the child has filed a 485 application, when we filed an I-539 application change of status from H4 to F1, we clearly mentioned that the adjustment of status has been filed. We never had any problem in their getting the F1 visas. Even though we thought that they will get problem, we were expecting, but they never got any problem.
Manasa is asking, it looks like they are a derivative applicant for an EB3 I-485, which is pending for more than 180 days, and they may have the opportunity to have an EB2 filed through a new employer, and is asking should they just change jobs using AC-21 based on their pending I-485, or have the new employer file just a new I-485 in the EB2 category. It does kind of depend on how far along this new employer is in the green card process for you. For example, if they already have gone through the perm process and are close to filing the I-140, there's no harm really in having them file the I-140 for you and in the EB2 category, so that you have another option. So you have the EB3 and I-485 in the EB3 category through your spouse as the principal applicant, and then you could potentially have an EB2 filing a separate I-485 in the EB2 category through your employer, with you as the principal applicant and your spouse as the derivative. So that would be fine. It does kind of give you options as far as having one foot in EB3 and one in EB2 and seeing which one becomes current faster. If your priority date is such that it's current or soon to be current according to the final action dates chart in the EB3 category, it may not be necessary, or if your new employer is not even started on the green card process, it may be easier to just stick with the EB3 category, but it depends on how far along they are and what your priority date is.
Nayan asked this question, my wife is on H1B, can I apply for H4 as a dependent? If so, what documents are required? Absolutely, why not? I came on H4 as a husband. H4 is not just for wives, it's also for husbands. I'm an evidence for it. I came on H4, I continued to on H4 until I got my EAD and started working as an immigration lawyer before I even got my green card. Yeah, absolutely. You can move to the H4 visa. Documents are required is your wife's H1B, your wife's recent pay stubs, marriage certificate, of course, proving that you're married to her, your current status, and if you're maintaining your current status. For example, if you're an H1B, you need the pay stubs. Absolutely, you can. Question from Madhu comes in. If the bill doesn't go through, what is going to happen if the priority date is January 2014 for EB2 and EB3? Will it get benefited? Madhu, if I look into the data provided by the USCIS, there are only 290,000 applications pending and 290,000 green cards. Yes, it should definitely be, if they do their job, just do their job, don't have to do anything extra. Obviously, they can. You should be getting the green card by end of this September if they do the job. Now that's where we need your help to have the USCIS do their job, and that's where we drafted a letter. Please write it.
Anil is asking about he may need to travel using his advanced parole for an emergency, and is asking what will happen to his wife's H4 status if he re-enters the US using the advanced parole card. So it is a bit of a gray area. One way of looking at it is when you enter the country in advanced parole, you're no longer in H1B status, which means your wife would no longer be in H4 status. She would still be in a period of authorized stay based on her pending I-485 application. But if she was using an EAD card based on her H4 status, for example, she may not be able to use that anymore. However, There is a memo that we have looked at where if your H-1B status is still valid not expired basically by the time you come back in advanced parole, there is a memo that says that your employer can file an extension of your H-1B status in that situation, which suggests that you can continue in H-1B and your wife can continue in H-4. So I would have discuss with your attorney and take a look at when your H-1B is expiring and see if you may be able to continue your H-1B status in that situation, especially if your wife has an H-4 EAD that she's using that she doesn't want to interrupt.
Natural Yogi has this question. Have you seen cases where people's priority dates are retrogressed and they still got the green cards? Yes, very rarely, definitely yes, but very rarely though. I would definitely recommend that you contact a lawyer. I'm not telling to just go and give up the green card. It's not that easy to give up the green card too, but I just want you to understand the pluses and minuses. What are the immediate risks that are available? What are the long-term risks that are available? And then you evaluate to do what further course of action that you want to do.
There's a question about an RFE for a birth certificate, and the response was sent in, but no update for a couple of weeks. And they're asking, when do I need to be concerned? I would say if you've just sent in the RFE response with the birth certificate documents a couple of weeks ago, there's no need to be concerned yet. Typically, USCIS says that from the time they receive an RFE response, give them about 60 days to make a decision. We have seen decisions faster than that from the field office, and I know you mentioned that this RFE was from the Harlingen field office. I would say the field offices are a bit quicker. They are able to act on cases faster, so you may get a decision before 60 days, but I wouldn't worry about anything right now.
Santosh has this question: if the daughter moves on to the F1, if the prior date becomes current, can she still get the green card? Absolutely. I mean, as long as she's protected by the CSPA and she's under 21, even if she moves on to the F1, you can add her. She doesn't have to be an H4 to add her to your green card. Absolutely not needed. All she needs to be is that she should be under 21 under the either naturally or by CSPA age. And you can add her to the 485 application even if they move to the F1. No need for them to be an H4 visa.
So Ganasan is asking about an H4 EAD that was approved, but it looks like the EAD card has A18 listed as the class instead of C26, but the receipt notice did show the correct category. So you can just request USCIS to fix it. It's just a typo. It doesn't invalidate the work authorization. There is an e-request function on the USCIS.gov website that says that you're requesting the fix of a typographical error. So if you filed the EAD, you can file the e-request asking them to fix that, or through the attorney's office that filed it for you. It should be pretty simple for USCIS to fix, but I will say that getting USCIS to fix just typos on approval notices or EAD, or even I've had to have USCIS fix a typo on an LPR card before. They put the wrong end date as the validity date, and it took actually a number of months for them to fix that, but it doesn't change her authorization to use that EAD card.
We know there's this question: what do you expect the priority date to move EB2 and EB3 if they work at the same pace as last year? Vinay, sorry, not Vinay. When you say same pace, are you meaning to say the same pace as the last year, same pace in the last quarter? That is very dynamic to depend on. If they go with the same pace as the last quarter, though, we'll be very good shape. They'll finish it. People have questions with regards to, does the biometrics delay due to the service center? Absolutely, you are right, Dreamer. If it is a Texas Service Center, it's completely different. And if it is a National Benefit Center, which starts with MSC, it's a different center. So if it's a Nebraska, it's different. The worst being the Texas, the best being which starts with MSC, also called National Benefit Center. In National Benefit Center, we have noticed that it's 1 month, 1.5 months, you're getting the biometrics notice. I don't know why these people are taking it. Should be an automatic generated, computer generated. Click a button, 1,000 biometrics should go. I don't know why they are not doing it. But yeah, they're doing it in one service center, another service center is not doing it. That's a perfect example we can show to the Congress. Hey, look, buddy, look, the biometric center, these people are doing, they are not doing, what's wrong with it? So that's one thing that you may want to point out, modify the letter that we have given there at the bottom.
Vinod is asking what happens if a H-1B company is purchased by another company but wants to retain the employees. So there's a couple ways that could happen. If the H-1B employer has just been acquired by another company, but the H-1B sponsoring company continues as its own entity with the same employer ID number, the same tax ID number, technically nothing has to be done in that situation. If the only change is a change in ownership, then nothing really needs to be done. You can continue on H-1B with the same company. Maybe there's a name change, but they can just update their name in the next application they file. If the H-1B employing company has been merged into the company that acquired them, so that that entity with that tax ID number no longer exists, those employees become employees of the acquiring company. You can continue on H-1B status with the new company if the acquisition agreement includes certain language that basically says the acquiring company is assuming the immigration liabilities and responsibilities under the LCA's labor certifications, I-129 petitions filed by the previous company. It just needs to be included somewhere in that purchase agreement between the companies, but if that's the case, the new company is considered a successor in interest. They don't need to file a transfer application to keep people in H-1B status. You would just file your next H-1B extension under that new company. If you have to go for visa stamping, just bring documents showing that that company is a successor in interest.
Jinesh has this question. Is A number mandatory in the 485 application? Can we file without the A number, even if we have one? It is not mandatory. I mean, we have not seen a single case rejected because the A number is missing. Absolutely not. Especially, I would suggest that if the dependent has an A number, though, we are recommending, based on our experience recently, definitely dependent should not keep the A number. Because what is happening is that they're pulling the dependents I-140. If they have other files, they're pulling those things. So with regards to the main applicant, there are choices that you can make if you want to, if you don't want to. Depending on, I would recommend that you refer that to a lawyer, whether it's discretion. But with regards to dependent, we recommend not to put that at all, the A number.
Sravan is asking what would happen if his priority date is current, but the prior employer has already withdrawn their I-140 petition for him. The perm with his new current employer is in process. So you have a couple of options. Basically, you could wait for the perm to go through with the new employer, hope that the priority date is still current by that time when they're filing the I-140 for you. Another option could be that if you are talking to your prior employer and if they are willing to have you rejoin them or at least make the offer to you to rejoin the company, just because they have withdrawn the I-140, as long as it had been filed properly the first time, it was filed on time and was approved, even if it was denied, the old company can still file an I-140 for you based on that same perm that they did for you several years ago. They don't need to go through the perm process again. They can just file a new I-140 for you. And if your priority date is current, you can file it concurrently with the I-45 application.
A couple of people are asking with regards to, hey, my friend got the EAD, my friend got the biometrics, I did not get it, and this guy got the biometrics. We filed on the same day, same service center. Here is the thing, guys. There is no such rule as first come, first serve with USCIS. There is nothing like that. They go randomly. We have seen green cards getting approved in 60 days. We have seen green cards pending for years. And unfortunately, we cannot contact them unless it crosses a processing time, which they put it on their website, which most probably is wrong. But at that time, at least we have a right to contact them and raise a service request. We tried to go to the courts. The courts are saying they don't have a jurisdiction. We tried several times and we got, we didn't got anything there. Yeah, obviously for the delays of the EADs, advanced paroles, you may have a chance of going to the courts. If you are interested in, you can contact Stephen Brown in our office. He's the person who does all those things. But for delay in the 485, for a delay in the biometrics, though, there is nothing we can do about it. Anything else?
So one question from Yasmin was, can we go to Canada for an H-1B extension? So pretty much everything we discussed previously about automatic revalidation and traveling to get an extension, H-1B or H-4 extension, it applies to Canada also. We usually mention Mexico because in order to do automatic revalidation through Canada, you need a visitor visa, or if you're a permanent resident in Canada. So because of that requirement for Canada, I would say most people end up going to Mexico, but it applies to Canada as well, automatic revalidation.
Anything else, Rebecca?
No.
Thank you for tuning in. If you want to contact us, you want to make an appointment with us or any of our colleagues, you can go to rnlawgroup.com. Our schedule is available there for you to make an appointment. Thank you for tuning in. Thank you, Rebecca.
Thank you.